What up? What up? What up? Oh, hold on a second. Hold on. Okay. What up? What up? What up? It's your girl T.U.O. We coming back with another clapback part two to Mr. John Porter, who wanted to jump in my DMs and call me all types of derogatory names and claim that he has a 25 million lawsuit against the government for wrongfully serving him and blase blase blah. He's misrepresenting his documents. Okay, let's get into it because I'm tired and I want to go to bed. And I don't like to deal with foolery and dumb shit. I just was like, you know what? Today is the day that, defendants are supposed to respond to his, admitted complaint. And I think they're going to prevail since a bitch nigga wants to talk about me. Now, look, I was going to show his paperwork, but I'm not going to do that because there can be some claims against me. Okay. To protect myself, I'm going to avoid showing. Sorry, hold on a second. I'm going to protect myself from any lawsuit claims against me. Okay. So I'm not going to show his paperwork. Y'all go ahead and do your own research. I actually have to sign back in. So his first complaint was filed July 8th this year. So, he still got time. I'm going to tell you something. They move fast. Matter of fact, because it took. I ain't even going to say nothing. And they move fast. That's all I can say. They move fast. Let me sign in. Okay. So it was 104 pages. Okay. I'm going to just be brief. I'm not going to read through it, right? I'm just going to skim through it because I don't care. I'm not a reader, I don't read. It's loading. Hold on. So if you didn't watch the part one, Mr. Porter jumped into my DMs and made false claims about women as parents and began to personally attack me. And just call me all types of names and make all types of assertion towards me for no reason. I did nothing to him, but ask questions. Now, I have his complaint open, which was filed again on July 8th of this year. I will not say the case number. If you go to his page and you see my comment, you'll see the page number. I mean, the case number. Unless he deleted them. But definitely look it up for yourself. So I'm looking at the first complaint. I can tell you right now that it's very improper. I don't know New York standards, what they require as far as font, size, space. I don't know. Let me see. New York procedures. I'm pretty sure it's standard all around. Oh, well, it's 12 points, double space, time Roman. And out here, it's 14. You have to have 14 points, unless it's in what do you call it? Um, Superior Court. Again, my information, these two videos are not legal advice. I'm not giving anyone legal advice or saying whatever. These are just my opinion about Mr. Porter and his situation. Um, Everything that I'm saying is allegedly. You can fact check for yourself, as I mentioned, by looking up the case number yourself. It is in North District of New York Court. Okay, federal court. But anyways, so like I said, as I look at it, it is definitely uh not proper procedurally because the font is incorrect. I get that there were a lot of defendants. There's a lot. But let's just get into it. We have Mr. John Porter III against the no. Whoa, I've never heard this county. An Anandaga, Anandaga County Family Court, Magistrate Lourdes Rosario, Magistrate Jeffrey Damachi Domachio Sweet Chowski, Chowski. I'm so terrible. Magistrate Ashley Dennett Fields, Magistrate Susan Nasky, David Primo, Sandra Saborin, which is a general counsel, chief clerk, which was David Primo, Adolfo, last name unknown, Carl, last name unknown, Adonis Dixon, excuse me, court clerk, Daniel Titus, commissioner of OTDA, Lisa Burns, DSS supervisor, New York State OTDA. What is OTDA? Uh, I have no idea. I'm assuming it's definitely a known Anondaga. Anondaga. I've never heard of that. Let me see how to pronounce it because I don't want to move on. Continue sounding ignorant. Anondaga. 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 Where the freak are you at? Onondaga. Okay. So we got Lisa Burns, New York State OTDA, New York State DSS, Lauren Corcus OTDA, Records Officer, uh, Shaquita Hayes, private litigant in her individual capacity. I think that's his that's the child's mother. So he's also suing in federal court the child's mother. Judge Julie Sissel. So let me just stop for a second. What did this lady do to you for you to bring her to federal court? What did this lady do to you for you to bring her to federal court? How did she violate your rights? That's crazy. The sense is not common. Judge Julie Cecil, New York State, judge. I just want to repeat that judge and magistrates. All these magistrates, that's crazy. They're judges. New York State Unified Court System, New York State Commission on Judicial Conduct, Governor Kathy Hachu, Attorney General Letitia James. Or Lydia. Bailiff Shaw, Bailiff Meyer, excuse me. It's just what? So you got, let me just count. 1, 2, 3, 4, 5, 6, 7, 7, 8, 9, 10, 11, 12, 13, 14, 15. 15. Where'd she go? 16, 17, 18, 19, 20, 21, 22, 23, 24 defendants. So you was like shooting the dice, like, I'm gonna get something. Somebody gonna stick, right? Something's gonna stick, right? And he's claiming verified complaint for declaratory relief, injunctive relief, and damages. It says 42 USC 1983, so some type of constitutional rights violation. Court proceeding violation. Let's just make sure, because I'm not really sure. Is it the same? No, 18. So let's see. 18 USC 1961, I think it was, to 1964. Racketeering, child. Rico. This fool is claiming Rico against his baby mama. Against his baby mama. Is he okay? Is he okay? Let's go. 28 USC. 28 USC. What was it? 1331. Oh, was it something else? Tradies. Maybe I put it in wrong. USC 1331 and 1328, I think it was. 1343. Statute granting the U.S. District Court original jurisdiction over certain types of case, but they differ in scopes and historical application, general federal questions. It covers any case where a federal law or constitutional issue forms the basis of the claim. Okay. Judiciary Law, Family Court Act, New York CRR. What the hell is that? 22 NYCRR 205.11. Is a New York court rule that governs the service and filing of motion papers in family court proceeding. It is part of the uniform rules for the family court. Okay. So moving on. So he lists all. He goes through it again. I may be wrong, but I don't think this is 12 points. I may be wrong though. It looks small. That's why. And it doesn't look like it's double space either. But I'm gonna go through this real quick. So the factual allegation, issuance of void AB initio support orders. In or around 2012, a petition for child support was initiated in, how you say it again, girl? Hold on a second. How you say it again? Onondaga. Onondaga. Initiated in Onondaga County Family Court against plaintiff John A. Porter III under docket number, and I'll just let y'all figure that out. The original 2012 to 2013 child support order were issued and enforced despite lacking proper service in jurisdiction pursuant to federal rule of civil procedure 4A. Summons must name the court and parties, be directed to the defendant, state the plaintiff's name and address, set the time to appear, warn of default judgment. Oh, warn, excuse me. Warn of default judgment and critically, what? Be signed by the clerk and bear the court seal. Now, where does it say? Okay, okay. In plaintiff's case, no valid summons bear the required seal or clerk's signature has ever been produced, and no affidavit of service was filed in accordance with CPLR 308. Mm-hmm. Mm-hmm. So he's saying that the clerk didn't sign it, that he was served with documents that wasn't signed by the courts. These omissions void jurisdiction ab initio. Additionally, 22 CFR section 727.2 prohibits public official forms misrepresent or omit material facts while acting under color of law. Defendant continue enforcement of the void order despite knowing of the absence of lawful service constitute a willful violation of federal regulation. The Supreme Court has held that subject matter jurisdiction cannot be presumed and must be proven with competent evidence. Basil versus Utah Power and Light Company. Jurisdiction may be challenged at any time when fraud or procedure defects are present. At any time. Jurisdiction. Jurisdiction may be challenged at any time when fraud or procedure defects are present, particularly when no affidavit of service or seal summons exist on record. Accordingly, the court lacked lawful jurisdiction from the inception of the 2012-2013 proceeding, rendering the result support order void under federal and state law. Enforcement of such order orders violates plaintiffs' due process rights under the 14th Amendment and constitute state response fraud and meet federal incentive quotas under Title 40. This same title he keep talking about. 25. Plaintiff was never properly served with the initial summons or petition in accordance with CPLR Section 308 requiring personal service or substitute service. I'm such a fact checker because I'm like, bitch, what? CPLR, right? CPLR Section 308. So, okay. It says the statute details various ways to serve a summons. Serving the person directly, delivering the summons to a suitable person, that would be a substitute service, at the individual's business or home, and mailing a copy, serving an authorized agent, and other methods prove difficult after making diligent effort. The summons can be affixed to the door of the person's business or home and a copy mailed, nail or mailed. Um, or excuse me, it says nail and mail. And other options are impractical. The court can authorize an alternative method. So they can just stick it on your door and mail a copy to you. So let's see what he says. USC section 1691 requires both a court seal and signature of the clerk for a lawful summons, or CPLR 2214B, which mandates a motion be served at least 8 days before the return date. No affidavit or service exists to establish that plaintiff was lawfully notified in time to prepare a defense, rendering the original 2012-2013 support order void ab initio for lack of personal jurisdiction. In a striking contradiction in 2025, the same court through Magistrate Jeffrey Damachowiski invoked against plaintiff to dismiss a motion for lack of timely notice enforcing the very 8-day service rule that had never been followed in the original 2012-2013 proceeding. In the same ruling, Damachowiski explicitly stated that an in-person appearance does not establish jurisdiction. A judicial declaration that further confirms the invalidity. Is that even a word? Invalidity of any prior order obtained in plaintiff's absence without lawful service. The court's selected invocation the court's selective invocation of CPLR section 2214B to penalize plaintiff in 2025 while disregarding it in the 2012-2013 proceeding underscores a pattern of arbitrary enforcement and unequal treatment, constituting a violation of plaintiff's 14th Amendment due process right. Further, the family court, let's see, okay. Furthermore, the family court refusal to apply the same legal standard retroactive to void the 2012-2013 order reveals a systematic intent to perceive the collection and enforce a financial incentivized support obligation under Title 4D of the Social Security Act. Title 4D condition federal funds on state enforcement performance, creating a direct financial conflict of interest. The family court refusal to vacate non void orders despite judicial admission that mere appearance is insufficient to establish jurisdiction, illustrate a vast interest in maximizing collection, not justice. Mm. Beginning in August 2013, plaintiff was subject to automatic wage garnish under the void support order deducted at a rate of $40 per week. I want to read that again. Beginning in August 2013, plaintiff was subjected to automatic wage garnishment under the void support order deducted at a rate of $40 per week. $40. In January 2025, the amount was unilaterally increased to $52 per week, despite no valid basis or judicial review, and despite the then pending jurisdictional challenge. I still want to do the math because I did the math before. That's why I said $160. Let's see, 52, $280. I mean, excuse me, $208 a month. Child, I am wiped at this foolery. As of July 1st, 2005, plaintiff has been deprived of plaintiff has been deprived of approximately $29,390 through these unlawful garnishment in violation of his Fifth and Fourth Amendment rights to property and due process. Fifth, 29. These garnishments were facilitated by OTDA and DSS acting under federal Title 4D program despite the absence of valid enforcement orders, a violation of 45. Well, if the judge makes an order, it's valid. Now, I don't know if you were sent documents that didn't have the judge's signature, but once it's put into record, you have every right to receive, you know, a signed order. At the same time, sir, order is an order. Like it doesn't change. Um the financial harm was further exacerbated by the consequences of the enforcement, including license suspension. Why was your license suspension, Mr. Porter? Credit damage. Why, Mr. Porter? And loss of employment opportunities, all based on orders issued without lawful jurisdiction. Patterns of obstruction. Now, I don't know how many of these are, but I'm not going through all of them. Right? I'm not going through all of them. I'm going to just read the titles because I'm exhausted. Patterns of obstruction in judicial relations. retaliations. In multiple instances, clerks told plaintiff he could not file jurisdiction motions without an attorney, contrary to Uniform Rule Section 205.11, which guarantees unrepresented litigants the right to submit files. Despite these obstructions, plaintiff persisted. In June 2005, Magistrate Jeffrey issued a formal ruling voiding the original support order for lack of jurisdiction and service. However, rather than halting enforcement, OTD, OTDA, DSS, and family court personnel continue to process garnishments, create a new constitutional entry for each post-voidance deduction. That's crazy. In addition, Magistrate Susan and Ashley dismissed plaintiff jurisdictional challenge prior to the Jeffrey ruling, retaliated against him for filing misconduct complaints and refused to recuse under Judiciary Law 14 despite conflict in prior filing. I would need to see that. I don't know. That's crazy. I wonder why. In parallel proceedings before Magistrate Lawless, plaintiff's custody rights were terminated following a hearing in which a culturally contextualized private phone recording was mischaracterized as abuse. Oh, Lord. Oh, Lord. Oh, Lord. Rosario refused to consider exculpatory evidence, including therapy records, character witness, and prior compliance with anger management, parenting classes, and child therapy, all substituted as part of the evidentiary record. So you have to take anger management? The way you attacked me, child. Like I said, this person ain't all right. He is not all right in the head, okay? It's something wrong. It's something wrong with him. FOIL suppression and exhaustion of remedy. Plaintiff submitted numerous Freedom of Information Law FOIL requests for affidavit of service docket history and clerical logs between January 2005 to the present day in 2005, most of which were denied, delayed, and redacted without justification in violation of public officers law. Plaintiff also submitted certified notice and complaints to New York State Commission and Judicial Conduct, Governor Kathy, Attorney General Letitia James, the OTDA DSS supervisory office, and the CSEA union representative. That's my obstruction and tampering with file evidence. However, upon return in mid-May 2025 to follow up, plaintiff was informed by Clerk Carl and Clerk Adolph that the filing did not appear in the court docket system despite multiple confirmation of receipt. Both clerks claimed the document could not be found. That's normal. Plaintiff documented the entire incident by transcript and video, which confirms that clerks failed to account for the missing files and that administrative retaliation occurred. So you think these individuals knew you personally and was like, I don't fuck with you? Um, okay, Title 4D, incentive, fraud, and motive for unlawful enforcement. Under the program, local child support agency and court receive substantial federal incentive payments based on performance metrics, including collection rates and compliance quotas. Internal correspondence and publicly available audit reports confirm that courts and county agency and reward based on the number of enforceable support orders, active collection, and sustain compliance with federal established benchmarks. Agents that fall below performance threshold face funds reduction and disqualification from bonus allocations. These financial incentives create a structural conflict of interest, encouraging courts and clerks to continue enforcement, avoid or defective orders such as the one issued against plaintiff despite clear jurisdictional violation and due process defect. Plaintiff ongoing garnish from 2013 to 2005, totaling approximately 29,390 directly benefited local agency participants in the federal scheme. Documented patterns of retaliation. How you say that word again? How you say it again? Child, why you stay there? Onondaga. Why you stay there? Onondaga County Family Court has a documented history of judicial retaliation and constitutional violation as established in Morin versus Torney. In that case, a former family court employee successfully sued Chief Administrative Judge James Torney, court attorney Thomas Belzano, and others for a systematic campaign of harassment, political retaliation, and abuse of judicial power. The court found that Judge Torney and his subordinates weaponized administrative powers against employees who practiced rights, and that court officials engaged in outrageous conduct designed to intimidate, obstruct, and retaliate under color of law. This precedent is not only factually similar to plaintiff's current experience involving denial of fair access, retaliation for practice filing, and collusion among clerks and judge, but also support plaintiff's claim under 42 U.S.C. Section 1983 and 1985 in the Civil RICO statute. Just as in Maureen, plaintiff here was retaliated against for protective act of denied a fair tribunal and subjected to coordinated interference and obstruction, especially by Chief Clerk David Primo and subordinate clerk. So, count one, violation of due process. Defendants acting under color of law deprive plaintiff of liberty, property without due process of law in violation of 5th and 14th Amendment to the United States Constitution. The enforcement of void child support order issued without lawful service or jurisdiction, wage garnish. Now, I'm confused with that because it wasn't voided until 2005. So anything after that in June would be voidable. So whatever you had to pay in June, that would be what? $160 you had to pay. That was voidable. Now, if the judge says that you shouldn't have been paying You shouldn't have been paying this entire time, then okay, you need to get some type of record of the judge saying that to support your claim. Termination of parental rights without fair hearing, recusal, or full consideration of exculpatory evidence. Denial of access to the court via deliberate obstruction by court clerks and judicial officer acting in administrative capacity. Ongoing dis ongoing deprivation, plaintiff's treatment, blah blah blah, and it goes on and on. Count two, and I'm telling you, it's like I think like 13 counts or something. Conspiracy to interfere with civil rights. Defendants conspire and coordinated with one another to obstruct plaintiff's access to court, suppress jurisdictional challenges, retaliated against protected filing, and deprives him of equal protection of the law. Count three, racketeering, RICO. Defendants through their position within the New York State OTDA, Onondaga, DSS, and family court formed an enterprise that engaged in a pattern of racketeering activity by using mail fraud to send garnishments notice of for void orders, obstructed FOIL to conceal extrinsic fraud and procedural defects, falsifying dockets and refusing filing to perpetrate enforcement. You would have to show intent. Abusing Title 4D incentive structures to prioritize collections overdue process. Uh, Count 4, declaratory judgment. An actual controversy exists between the parties concerning the enforceability of the 2012 to 2013 support order and the legality of the subsequent garnishment and ruling. Plaintiff seeks a declaration that the original order were void ab initio and lacked jurisdiction. All enforcement acts from 2013 to present were unconstitutional and unlawful. Evidence tampering and clerk basis obstruction of action to courts. Defendants acted under color of law, and I think he's just repeating what I've already read, so I'm not going to read it again. First Amendment retaliation. Plaintiff engaged in protected activities by filing formal complaints, FOIL requests, judicial notice in motion challenging jurisdiction and retaliation. Defendants delayed and refused to file defendants' documents, retaliated through adverse custody ruling. Count 7, violation of equal protection. Thank you. Violation of equal protection, 14th Amendment. Plaintiff was treated differently from similar situation litigants who received evidentiary hearings before custody was revoked. Count 8, negligent supervision and failure to intervene. Supervisory defendants had actual notice of constitutional violation via plaintiff certified complaint. We're at 9. Manel claims for policies, customs, and practice. You know what? I want to see. Like, which one is he going against his baby mama? The Constitution violates what is the policy, custom, and practice, and a constitutional violation. Excuse me. Violation occurred pursuant to official policies or customs, including systematic refusal to investigate, support ordered service issues, denial of docket access by clerks, and so forth and so forth. Count 10, injunctive relief for ongoing harm, enforcement, and injury are ongoing, not merely past. Plaintiff is still being garnished weekly under void order. Uh, so it's 10 counts. Judicial and quasi judicial immunity do not apply. Plaintiff brings this action against defendants, Magistrate Susan, all the defendants, in their individual capacity for acts committed outside the scope of judicial duties and in the clear absence of jurisdiction which removes the protection of judicial immunity. It is well settled law that judicial officers are not immune from liability. Okay, okay. Um, um, okay. Um, so, uh, so, okay. Monetary damages, right? So he said compensatory damages for 5 million, treble damages for 15 million, and for punitive damage 5 million. So that will be the 25 million that he refers to. That's in his initial complaint, right? And whatever the judge may deem proper, right? Constitutional violation first, fifth, fourth. Oh, excuse me, 14th. Um, New York proceedings is different. So after that, he has his exhibits, right? Well, you know what I want to see? The service. Let me see. Let me go through it again. Sorry. The child support service. Original child support order from established original jurisdiction defects. So let's see. His handwriting is trash too. All you had to do was write Exhibit A, sir. You didn't have to. You didn't have. Yeah, I'm so glad I don't live nowhere else but Cali. Uh, let's see. Is this really only 28? Child, he really, he really. I'm sorry. I'm like, he really filed this federal case against his baby mama. Yes, he really did. This nigga is crazy. I could never. She a better woman than I ever be. Cause what the fuck? Okay, it has date time. He has that. Ooh, excuse me. Now it says it was sent July 3rd, 2020. I mean 2012, and it has the clerk of the court. It says served by 4D. On your failure to appear as herein directed, a warrant may be issued for your arrest. I don't know if this is something else, but but is this the proof of service? I know it's a conform copy. Okay, the baby do got his last name. So he had a baby, and then the following year he met this lady. That's crazy. That's crazy. Um. Okay, it is signed. Is it still A? Okay, so I'm trying to see where the judge said it needs to be thrown out. Do you have that? Okay, so it's Exhibit C. Child. All right. Okay. Motion under each above reference docket number has been filed by petitioner. Okay. As referenced above, seeking multiple relief, and John Porter having personal appearance on June 18th to argue such motion in the court, having reviewed the affidavit of service of the notice of motion reference above docket number and motion in the court, finding that service of the notion. Huh? All right, I'm reading through this letter because I'm kind of confused as to the motion that they're referring to. Eh, At a term, the family law of the state of New York held in and for county of Another, Ananda, The I'm gonna need you to move out. See, out here they'll name the motion that was filed and like why y'all were there, the appearance and everything. Okay, so you're the petitioner. The motion under each of the above docket. Okay, so docket. So motion 2, motion 7, and motion 8. I don't think he understood. So these are the dockets that you filed as referenced above in seeking multiple relief, and John having personal appearance to argue such motion, and the court having reviewed the affidavit of service of the notice of motion referencing the above docket numbers and motion, and the court finding that service of the notice of motion was untimely pursuant to. Okay, so you said he found that you served them untimely, but he didn't feel like you were served untimely. And let's see if they have a seal here. Because I know what seal he's talking about. Yeah, it don't have a seal here. It just has the judge's signature. Oh, is this the seal? No, this is, you know, the mailing service. And the judge attached a New York City civil court procedure basically on motion paper service and time. So even he know. I don't know, child. I don't know. I don't know. But what I wanted to get into basically is the defendant's response. Okay. Child, getting through all that 100 and some pages, and I ain't no better, but child, I'm exhausted. Let me try to get through this real fast. I got signed out. Okay. So the defendants had a beautiful response. Okay. Beautiful response. Um I don't know why this thing tripping. There we go. So let's see. Where's the answer? They move fast up in here. He filed this thing on the 8th. They had back-to-back appearances and all types of stuff for an entire month. Okay, so the defendants requested for. Okay, so they responded in August 29th. Okay, so they filed a motion to dismiss. Um, let me look at the recommendation. Where is that at? Was it afterward? Okay, that was afterward. Okay, that's crazy. They basically reset the answers for certain individuals um that don't have attorneys. And one being the child's mother, which is crazy. Um, they don't tell you who this stuff is filed by. That's what I don't like. Like in Superior Court, they'll tell you uh, that it's filed by such and such plaintiff, petitioner, or defendant, respondent. Okay, this is by him. Okay, we don't care. Hold on. I do want to see that. Never mind. Sorry. I want to see that again. Let's see. Notice of supplemented authority regarding driver's license suspension. On June 6, 2025, Department of Motor Vehicles suspended plaintiff's driver's license for alleged failure to pay child support. So he don't have a license. God damn. God damn. If I was in this situation, bro, I would be paying. I would still be paying until, because that's more money for me. Okay, that's more damages to me. Because if I don't pay, then, but for you to willfully not pay and cause yourself harm, motion to dismiss. Okay, it's crazy work for me. Um. So. Uh. Uh. Whoa. So this was the mother who filed this. Wow, I wasn't expecting this. So she said, please take notice that upon the accompanying motion to dismiss defendant proceeds pro se, will move this court at the United States District Court for the North District of New York for an order dismissing plaintiff's complaint with prejudice pursuant to Federal Rule of Civil Proceedings 12B1, 12B6. United States. Motion to dismiss. Defendant Hayes respectfully moves this court to dismiss plaintiff's complaint. The same civil proceedings. Lack of subject matter jurisdiction. Federal court do not have jurisdiction over matters involving divorce, child custody, or child support. The racketeering. Sorry. The Rooker-Feldman. Oh, you know what? That sounds familiar. Doctrine prohibits this court from reviewing or overturning state court order child support orders. Under 28 USC, full faith and credit. Under 28 USC, child support order issued by state courts must be given full faith and credit by all other courts. Waiver of service. Plaintiff attended all hearings in 2012, 2013 concerning child support and did not file an appeal. By participating in these proceedings, plaintiff waived any alleged defects in service. Wow. Wild. That's wild. I didn't know that she filed this when I looked at it. I thought it was the attorneys. Waiver of service plaintiff. Okay, I read that. Failure to state a claim. 14th Amendment restricts action by the government, not private citizens. Defendant is not a state actor and cannot be sued for constitutional violation. I know that's right, girl. Res judicata. Excuse me. Plaintiff had a full opportunity to litigate the child support issue in 2012, 2013, and failed to appeal. These claims are barred by res judicata. Is your baby mama an attorney? Improper defendant. Child support enforcement is carried out by state agency and court, not defendant. Plaintiff claims are directed at the wrong party. She answers. Defendant denies plaintiff's allegation that he was not properly served. Plaintiff attended all hearings in 2012, 2013 concerning the child support, was given the opportunity to be heard, and did not file any appeal. The child support order attached as Exhibit A shows that plaintiff appeared at hearing 2012, 2013. Paragraph 2, defendant denies that the family court lacked jurisdiction, has exclusive jurisdiction over child support matters. Paragraph 3, defendant denies that any action violates the 14th Amendment. Defendant is a private individual, not a state actor. Paragraph 4, defendant denies plaintiff's request to have child support obligation dropped in federal court. Federal court lacks subject matter jurisdiction to modify state child support order. Affirmative defense, lack of subject matter jurisdiction. 2, failure to state a claim. 3, res judicata. Plaintiff litigates this matter. Plaintiff litigated this matter in 2012, 2013. Improper defendant, statute of limitations. Statutes of limitations. Relief requested that the court dismiss plaintiff complaint in its entirety with prejudice and grant any and other relief deemed proper, meaning pay my attorney's fees and any damn energy that I had to do to prepare these documents. That was the mother. The mother. The mother. Okay. I know that's right. And I thought I was tripping. That was her paperwork. Okay. So she filed her motion to dismiss. And then the recommendation came down a few days later. A few days later, it came down. Okay, I'm waiting for it to open. I'm going to just read the recommendation. I'm not going through all the facts and stuff. Y'all heard the facts. Y'all heard what this person is claiming. All I know is I feel sorry for the mother. That man is a fraud and he has issues. Serious emotional issues. The nerve of him. The nerve of this man. It's loading slow. My bad. Okay. The Honorable Elizabeth refers Porter's complaint to this court to determine whether the district court has subject matter jurisdiction over Porter's claim and whether any and all of Porter's claims were frivolous for the reason discussed below. The court recommends findings that the district court lacks subject matter jurisdiction over all Porter's claims, and alternatively, if the district court determines that it does not have subject matter jurisdiction, that the complaint be dismissed. I'm not reading the background. Discussion. First, the court recommends finding that the district court does not have subject matter jurisdiction over Porter's case. Alternatively, if the court finds that it does not have subject matter jurisdiction, the court still recommends denying Porter's. The court finds that it does have subject matter jurisdiction. The court still recommends denying Porter's claim because the government entity defendants are immune. And there are no facts pled to establish any defendants acted in their personal capacity. No facts. I'm not reading that. Legal authority. Oh, and it clearly, the judge read the mother's motion to dismiss, because it says Roker Feldman doctrine stripped the district court of subject matter jurisdiction in this matter. To the extent Porter is challenging the final outcome of any of his state court proceedings, his claims are barred under the Roker-Feldman doctrine. The Roker-Feldman doctrine bars federal court from exercising jurisdiction over claims brought by state court loser complaining of injuries caused by state court judgment rendered before the district court proceeding commenced, and inviting district court review and rejection of those judgments. The Roker-Feldman doctrine has 4 requirements. The plaintiff must have lost in state court. The loss must have occurred before, the district court proceeding commenced. The plaintiff must complain of injuries caused by a state court judgment. The plaintiff must invite district court review and my mind went somewhere else. The plaintiff must invite district court review and rejection of that judgment. Here, Porter complaints is riddled with requests for this order to review or reject state court decision. The original child support order issued as void ab initio for lack of jurisdiction and directs the family court to formally vacate and dismiss said order in their entirety. So the Roker-Feldman doctrine strips the district court of subject matter jurisdiction to hear Porter's case. Accordingly, the court recommends a finding that the district court lacks subject matter jurisdiction over Porter's case. Oh, my Lord Jesus. And because there are 23 defendants, the judge has to go through each of them. Let me make sure. Okay. The district court should dismiss Porter's claim against the immune defendants. Should the district court find that it does have subject matter jurisdiction, this court still recommends dismissing Porter's complaint with prejudice and without leave to amend as the defendant's Onondagas County Family Court, all the defendants that work for the county, basically. Let me see, is the mother in here? Because they are immune from suit. No, she's not. All judged all judge defendants are immune from Porter's suit. Judges have absolute immunity from judicial acts performed in their judicial capacity. Generally, acts arising out of or related to individual case before the judge are considered judicial in nature. Cleaned up. Judicial immunity applies even when the judge is accused of acting malicious or corruptly. The only two circumstances in which judicial immunity does not apply is when the judge takes action outside their judicial capacity or when the judge takes action that, although judicial in nature, is taken in absence of jurisdiction. All clerks, defendants are immune from Porter's suit. I want to get to the mother. All state entities, the government, and the state attorney generals are immune from Porter's suit. Oh my goodness. The bailiff defendants are immune from Porter's suit. Damn. Porters are alleged that he is suing both bailiffs in their personal capacity to the extent the claims fail because the complaint does not allege a single act the bailiff took in their personal capacity, so the complaint in their respects is deficient under Federal Rules Civil Procedures 8A. The government attorney defendant is immune from. They said form suit, but I know what they meant. From suit, okay? Porter allegation as the commissioner. As to the commissioner, Department of Social Service supervisor must be rejected as well, without prejudice and without leave to amend. I'm just going to get to the point because Porter has not alleged that either defendant was personally involved in the purported wrongdoing. Lord Jesus. Porter complaint fails to comply with Rule 8 as to all defendants named in their individual capacity. He picking apart that complaint. Opportunity to amend. Generally before court dismiss a pro se complaint or any parts of a complaint sua sponte. They should afford the plaintiff the opportunity to amend at least once. You hear that? The reason why this whole 10%, I'm 10%, is because it's supposed to happen. They give you a chance to amend it. You're not special. Generally, before courts dismiss a pro se complaint or any parts of a complaint sua sponte, they should afford the plaintiff the opportunity to amend at least once. Hayes filed a motion answer seeking dismissal of the complaint on August 27, 2025. I'm sorry. What is that referring to? As to Hayes, the court recommends dismissing Porter's claims against Hayes without prejudice. Oh, and without leave to amend. Oh, that's not right. That's not right. Okay. Oh, wow. So that's why. Okay, hold on a second. Hold on. The clerks. Sorry, because I just saw some of them were without prejudice, meaning that he could still file. Yeah, he said, oh, wait, no. That's for something else. It don't say with prejudice or not, but it just that they're immune. Um, okay. So yeah, against the mommy, it's with prejudice. Where did it go? Damn it. I'm so damn tired. Okay, here we go. So without prejudice, meaning he can file against her again. Opportunity to amend. Yeah, okay, I read that already. Here the court recommends dismissing Porter's claim with prejudice and without leave to amend because any amendment would be futile. Porter cannot cure the lack of subject matter jurisdiction, but if the court finds that it has subject matter jurisdiction, it should dismiss Porter's claim with prejudice and without leave to amend as to defendants. All the defendants that work for the government and judge and attorneys. Uh, but it should dismiss Porter's claim without prejudice and with leave to defendants uh, and all government entity defendants named in their individual capacity because the opportunity to amend theoretically would not be futile. Okay. I don't see her name here. And I think, see, the courts, and it's showing its hands too. The courts are so busy worried about uh their buddies and stuff that they left out. And I just want to make sure. Yeah, they left out the mother. Um yeah. Wild. So that's the judge recommendation, which I enjoyed so much. Um Miscellaneous. What is this? Plaintiff object to magistrate judge report and recommendation. Child. Well, he objected, but let's see what he did. Okay. Order on motion for. Let me tell you something. They didn't even respond to my damn objection. Let's just get to the point. District courts have the inherent authority to dismiss a complaint sua sponte as frivolous, even where, as here, the plaintiff has paid the required filing fee if the claim lack an arguable basis either in law or in act. I am so tired. Um, uh, Oh, my butt hurt too. Although a second circus has repeatedly warned against dismissing a complaint sua sponte without providing notice and a opportunity to be heard, it has nevertheless articulated several exceptions where sua sponte dismiss of a fee paid complaint may be appropriate. Most significantly, dismissal without notice is permissible when it is, unmistakably clear that the underlying case is frivolous or the court lacks jurisdiction. Pro se submissions are reviewed with special solicitude and must be construed liberally and interpreted to raise the strongest argument that they suggest. Amended complaint. Plaintiff filed his proposed amended, his proposed, okay, that doesn't mean his actual complaint. So he filed his proposed amended complaint within 21 days after service of what the court construed to be pro se defendant Hayes' motion to dismiss. Accordingly, plaintiff amendment is permitted as of right pursuant to Federal Rule Civil Procedures 15A1B, and the amended complaint is deemed the operative pleading. Plaintiff amended complaint identifies the following defendants. Onondaga County Family Court Chief Clerk David Primo in his individual capacity. Onondaga County Family Court Clerk Carol Connor and Adolph Eckstein in their individual capacity. So the mother is removed, thank God, because that's psychopathic. The allegation raised in plaintiff's amended complaint are as follows. Onondaga County participated in federal Title IV child support program. Public record shows the county received $594,791 in federal performance incentive payments in 2022. While Title IV funds do not dictate individual clerk a decision, they create institutional incentive to prioritize child support collective over due process, fostering a culture of obstruction against litigants who file jurisdictional challenges. This financial structure provides context for systematic obstruction. So he goes through um, Porter's claims or factual information. Um, As a result of a formative event, he has suffered ongoing harm, including the suspension of his driver's license and continued wage garnish. So the amendment complaint asserts 1. A First Amendment claim for denial of access to court under 42 U.S.C. 1983 against defendants. 2. A Monell claim under 42 U.S.C. Section 1983 against Onondaga County. Plaintiffs seek compensatory, punitive, declaratory, and injunctive relief along with costs and fees under 42 U.S.C. Section 1983. Plaintiff's amended complaint remedies a sufficient number of remedies a sufficient number of deficiency identified by Magistrate Judge Cates based on sua sponte dismissal with respect to the First Amendment access to court claims against defendants, asserting in the amended complaint, the court finds that plaintiff's allegations do not on their face establish a lack of subject matter jurisdiction, nor are they frivolous as a matter of law. Okay. Plaintiff's manner claims against, however, fails to satisfy the same standards. Okay. Okay. So that was the judge's decision to allow the amendment through, right? So he filed it, um, and then the answer was reset for the defendants. Um, and they filed their motion for dismissal today. Oh, you know what? Not that one. So I was reading it. I skimmed through it. I'm probably gonna have to do a part 3 because I am like tired and I have an appointment tomorrow. Okay, so primary statement in July 2005, plaintiff filed a complaint against civil rights, alleging civil rights and racketeering causes of actions against Onondaga County itself, as well as various other individuals employed by Onondaga County Family Court. Yeah. In the proposed First Amendment verified complaint, plaintiff alleged that defendant all clerks with the family court violated his First Amendment rights to access the court by taking various steps to make filing difficult for him, ultimately resulting in the suspension of his driver's license and continuing wage garnishment. As relief, plaintiff demands compensatory punitive damages against defendants, declaratory judgment that defendant's conduct violated plaintiff's First Amendment rights, and costs and fees under 42 USC Section 1988. The proposed First Amendment verified complaint must be dismissed with prejudice because plaintiff has not and cannot allege a viable claim for violation of his First Amendment right of access to the court. Plaintiff alleged that defendant denied him access to the family court through a variety of actions related to his attempt to file a document in January through March 2025. This claim must be dismissed with prejudice pursuant to Federal Rule Criminal Procedure 126B. I mean, B6, because plaintiff has not and cannot allege sufficient factual material to state a First Amendment claim to relief that is plausible on its face. I may not make it through. Under Rule 12B6, a defendant may move to dismiss a complaint for failure to state a claim upon which relief can be granted. Jackson versus Onondaga County. In order to survive a motion to dismiss, a complaint must contain sufficient factual material accepted as true to state a claim to relief that is possible on its face. Ultimately, when the allegation in a complaint, however true, could not raise a claim of entitlement to relief, or where a plaintiff has not nudged its claim across the line from convincible to plausible, the complaint must be dismissed. The state To state a claim for relief based on a denial of access to court in violation of the First Amendment, a plaintiff must allege an action by a defendant that results in denial of access to court. Christopher versus Harbury. While the other circuit recognizes a cause of action where access is only partially denied, but results in prejudice, the Second Circuit requires that the judiciary remedy in the underlying action be completely foreclosed. Salsa versus Marquez. Uh, in addition, the underlying cause of action, whether anticipated or lost, and an element that must be described in the complaint just as much as alleged must describe the official act frustrating the litigation. A plaintiff can allege either that systematic official action frustrates a plaintiff or a plaintiff class in preparing and filing suit at the present time, or a specific case that cannot now be tried or tried with all material evidence, no matter what official action may be in the future. I'm moving on. First, while plaintiff allege a pattern of systematic bad faith administrative obstruction by court clerk that blocked plaintiff from ever obtaining a hearing, on the merits of his jurisdictional challenge, and that access to Title IV-D funds created institutional incentives to prioritize child support collection over due process, fostering a culture of obstruction against litigants who file jurisdictional challenges. There is no factual support in the proposed First Amendment verified complaint for these conclusor, conclus, conclusory allegation. The event complained, the events complained of relate solely to the events complained of relate solely to a plaintiff's attempt to file without any suggestion that any other litigant might encounter similar problems. It is also noteworthy that these conclusions, systematic allegation, concern only Onondaga County, who is no longer a party to this matter, and the remaining defendants are not employees of Onondaga County, and their actions cannot create a basis for municipal liability. Plaintiff reliance on Marin versus Tomey has nothing to plaintiff's conclusory allegation of systematic obstruction because Morin is concerned with workplace retaliation and hostile work environments claims, not liability for coordinates harassment of pro se litigants as plaintiff's claims. Second, plaintiff cannot allege injury because he was able to file documents with the family court. This is apparent from plaintiff's admission under procedural entrapment. Entrapment, excuse me. I'm so tired. That he did not file papers, that he did file papers in June 2025. In addition, while plaintiff alleged that dismissal of those same paper denied him access to the courts, this dismissal was without prejudice and there is no indication of the proposed First Amendment complaint or attached document that plaintiff was unable to refile. Similarly, nothing in the proposed First Amendment verified complaint suggests permanent removal from clerk's office or the other ways of accessing the family court, such as phone, email, mail, were insufficient. Finally, plaintiff appealed several family court orders. As such, he cannot allege the complete denial requirement in the second circuit, or even the partial denial with prejudice allowing in other circuits. Third, let's get the final. Plaintiff failed to identify the underlying cause of action with specificity, specific, specificity, specificity. He must plead this element with the same specificity as all other elements. Hence, the need for care in requiring that the predicate claims be described well enough to apply the non frivolous test and to show that the arguable nature of the underlying claims is more than hope. While plaintiff alleged that he was prevented from getting a full hearing on the merit regarding his uh, jurisdictional challenge, he does not identify the cause of action. Dismissal of proposed First Amendment verified complaint with prejudice is appropriate because amendment is futile. Should I go on? No amendment can change the fact that defendant is foreclosed from relief in the Second Circuit because his access to family court has not been completely foreclosed. Accordingly, dismissal with prejudice is appropriate. Dismissing First Amendment right of access claim with prejudice where access to the court was not completely foreclosed, as demonstrated by facts that plaintiff brought an action in that court. The proposed First Amendment verified complaint must be dismissed with prejudice because defendants are protected by judicial immunity. Here, many of the actions alleged by plaintiff fall within the ambit of tasks that are essentially to the judicial process. Plaintiff alleged that 1. On January 21st, 2025, defendant Primo personally obstructed the submission, dismissing plaintiff's filing and refusing to provide assistance. 2. 2 days later, defendant Dixon refused to accept defendant's filing after consulting with defendant Primo. Third, on January 30th, 2025, after defendant paid to mail the filings, defendant Dixon denied that they received the filing. Defendant O'Connor accepted defendant's filing. These same filings later disappeared from the records, although defendant failed to allege who caused this disappearance. Defendant Eckstein had plaintiff removed from the clerk's office when he confronted defendant O'Connor. And 7, defendant Eckstein required plaintiff to submit any questions for defendant Primo in writing. As to the first, plaintiff supplies nothing more than conclusory allegation as to defendant Primo's conduct on January 21st, 2025, and he does not allege the defendant Primo actions were taken outside the actions within his position as chief clerk. Thus, plaintiff allegations are found on discretionary action performance by defendant Primo in his official capacity as chief clerk, and defendant Primo is entitled to judicial immunity as to these allegations. As to the second and fourth allegation, these related directly to defendant, directly to the decision by defendant Dixon and O'Connor to accept filings from defendants. There are various rules that must be complied, because that's what I'm trying to figure out. Why didn't they file it? What kept them from filing it? There are various rules that must be complied with in filing documents and matters before the court. Family court, and filing is not as of right. Accordingly, the decision whether or not to accept a filing is a discretionary act within the official capacity of family court clerks, and defendant Dixon and O'Connor are entitled to judicial immunity as to these allegations. As to the third and fifth allegation, plaintiff only alleged that defendant Dixon denied receiving the filings which plaintiff had mailed, and that defendant O'Connor accepted documents that were later lost in unknown circumstances. At best, these allegations boil down to claims of incompetence in performance for discretionary acts of filing plaintiff submitted documents. And let's just get to the last. The proposed First Amendment verified complaint must be dismissed with prejudice because defendants are protected by qualified immunity, baby. Qualified immunity. They're going to always hit you with that. Although we have not passed on the issue, many courts have accorded clerks only a qualified good faith immunity from liability arising from ministerial acts. Public officials are entitled to qualified immunity on Section 1983 claims unless they violated a federal statutory or constitutional right, and the unlawfulness of their conduct was clearly established at the time. In determining whether a right is clearly established, court consider 1. Whether the right was defined with reasonable specificity, I can't even say it. Specificity. I lost my spot. Whether Supreme Court or Court of Appeal case law supported the existence of the right in question. And 3, whether under pre-existing law, a reasonable defendant would have understood that his or her actions were unlawful. Here, qualified immunity applies because neither the Supreme Court nor the Second Circuit have held that error in an underlying matter can violate a legitimate First Amendment right of access to the court. The Supreme Court has recognized that the First Amendment denial of access claim generally falls into 2 categories. In forward-looking claims, plaintiffs challenge systematic official actions that are temporary roadblock to pursuing litigation for a class of litigation. For example, indigent plaintiffs who cannot afford a filing. The relief sought in those cases is generally in order removing the temporary roadblock and free the plaintiff to pursue the underlying litigation. Though the proposed First Amendment verified complaint alleged a backward-looking claim, this is clearly for the allegations made in the relief sought. Regarding the remaining defendants, plaintiff alleged only individual actions related to his filings of documents in his matter before the family court. Plaintiff conclusion. Plaintiff has failed to state a claim to relief, and no amendment can remedy this. In addition, defendants have judicial and or qualified immunity that completely foreclose plaintiff claim. Accordingly, the proposed First Amendment verified complaint should be dismissed with prejudice. Oh my Lord. I am so tired. I am so tired. Let me tell you something. When I tell you I am laughing in the inside, I just feel so warm. As cold as it is in my home, I feel so warm inside knowing that this nigga's case, I'm sorry, that this man's case is going to be dismissed. And I failed to read the amended complaint where he only asked for what was his relief. That's all I'm reading, right? Because we already know the facts behind it. And let me tell you something. When I tell you the first complaint was 100 and something pages, the amended complaint is only 7 pages. No exhibits. No exhibits. Okay. That's how exhausted he is. He said, you know what, forget it. He said, trial by jury, child. So he said compensatory damages in the amount not less than $1 million. It went from 5 to 1. Punitive against defendants in an amount sufficient to punish and deter further misconducts. Declaratory judgment. Um, um, Injunctive relief, permanently enjoining defendant and their successor in office from obstruction, interfering with, or denying public access. Attorney's fees and costs. Such other and further relief as the court deems just, equitable, and proper. Now, it went from $25 million to $1 million because he don't even believe in his case. He don't believe in his case. And let me tell you something. How smooth that mama got out that case. She was like, "Child, if you don't get me up out of here, I don't know why you arguing with me. So you put a RICO case on your baby mama? That's crazy work. That's crazy. To even have her associated with a RICO case is crazy work. Like, how bitter are you, sir? You bitter. You're a bitter baby daddy. It's sad. It's sad, sir. I feel sorry for her. But, that's just my opinion. That's just my opinion. I'm tired. I went through it. Y'all getting played. Y'all letting this man con you out your money. Tell you that he can boost your credit in 3 months. 200 points in 3 months. That's fraudulent. That's allegedly. Allegedly. Y'all can go look up the case out for yourselves. This $25 million case that he got going on ain't no $25 million case. Okay? Ain't no 25. I smelled him a mile away. God sent me as one of his fighters to help y'all out. Now, if y'all want to proceed to move forward following this man, that's on you. That's on you. I'm not going to force anyone to believe anything I'm saying. That's why I'm reading verbatim what's written down. So you can go look it up yourself. Okay? You go look it up yourself. You guys are letting this man con y'all into believing he's going to win an action against the government. The government of an entire state, an entire organization. It's not going to work. especially with the claims he got. Now, mind you, the complaint looks astonishing. It looks amazing. Okay, I'm not hating. It's I forgot the word I was looking for because I'm so tired. But the complaint, the flawless, like right, it looks flawless. But according to the judge, it's frivolous claims. And even your own child's mother said statute of limitation is up. So how you gonna help some other people with their case when you couldn't even help yourself? You couldn't even help yourself. You waited almost 10 years? 13? No, yeah, it's been over 10 years. You waited over 10 years to bring a claim against the county, against the government, and your child's mother. How can you give somebody advice? I don't understand. I don't get it. And who in their right mind is listening to you? And why are they cheering you on? It just shows, you know, everybody ain't right up there. You know, people believe in AIs. People, what is it called? Fearmonger. I really hope that this man is investigated and prosecuted to the highest form because the way he is really putting out this information and encouraging people to bring claims against their government for for something that's been put in place to protect their children, to protect the homes of their children, whether it's with the person they disdain at the time, is crazy. I personally encourage men who have it together, who go to therapy and work out their mental issues, emotional issues, childhood issues, and work on themselves. Excuse me, he listed the things that he did doesn't make him right, does it? Because he's still acting the same. He still got issues. Calling me out my name, talking about me. I didn't even show y'all the pictures he sent to me. I didn't even show you guys the pictures that he sent to me of myself. Like he began sending pictures of me. And I'm like, what the hell? I'm just sending stuff that I saw on the internet, right? He got so in his feelings. He started sending me pictures of myself. I didn't even recognize myself. Okay, I didn't even recognize myself. I was like, who's that lady? He took my picture off my page and began, and I'm wondering like, why, what is this on my head? He took my picture and made these. And remember, he said, I need to go ahead to massa. So he think I'm a field nigga. And I guess he's a house nigga. But I said, you're a coon, sir. Straight coon. He just kept repeating it. Kept repeating it. And I said, you're a coon, sir. I just kept saying, you're a coon. But I figured it out. I sent some AIs. It's not my best work. You feel me? It ain't my best work. You feel me? I did what I could. I don't believe in that stuff. You know? I did what I could do. He was mad. He was in his feelings. That I found him out. I sniffed him out. Okay. Sit up there and send me motherfucking AIs. I said, I'm over here reading these paperworks. Look at him. Look at him. Don't he look good? I did a good job on this one. Get it, mama. Get it, mama. Get it, mama. Oh, he was mad. He was mad. Okay. Look at here. Look at here. I'd rather be accused of being a transgender than a deadbeat father. Y'all have a good night. All right. Like, comment, and subscribe. Go ahead and check that case out for yourself. All right. Bye.